So where do you see yourself as an appellate advocate being of the most benefit to a trial attorney?
Well, I kind of touched on it in the beginning, where I think as you know, a lot of lawyers who don't have in-house appellate counsel to walk down the hallway and consult will, you know, oftentimes not think that they need to bring on an appellate advocate until the verdict is rendered, and they're thinking to themselves with the client, either, you know, we lost and can we take an appeal, and they have to then go back and go through the record and try and find things that they might want to raise on appeal. But on appeal, you know, if you don't preserve your appellate rights, if you don't preserve your objections, you know, you can really tank your appeal. And, you know, I've dealt with cases myself where trial lawyers who've lost at trial will try to bring in issues that they weren't properly preserved before the trial court, and therefore the trial court didn't rule on them. And they just, you know, I was able to very easily, you know, rest on those legal principles where an appellate court is not going to decide an issue raised for the first time in a reply brief, or not properly preserved at trial or in a motion or anything like that. And so that's where I think that an appellate advocate could really help before it goes to verdict, where, you know, you can ask someone to come in and say, you know, some issues also might involve an interlocutory appeal. Some things you don't have to wait for final judgment. And so when you get someone involved who might be able to issue spot and see things ahead of time, whether it's drafting jury instructions in ways that are not going to get you in trouble, where let's say you do win at trial, but you haven't done something the right way that gave your opponent the opportunity to have a really good solid ground to appeal that. And so where I think an appellate advocate can be very, very useful is not only doing stuff like that, but also, as I mentioned, in what's called critical motions practice. I do a lot of writing, and we are professional writers after all. I mean, all lawyers really are, but I think that appellate attorneys have really honed that skill. And you can really, you know, if not flat out get a case thrown out of court if you're defending, or win summary judgment if you are a plaintiff, and it can really change the entire dynamic of the entire case with effective motions practice. And then after verdict, you know, obviously, I think that a lot of trial attorneys oftentimes will say, I want to keep this myself, and can hurt themselves in a way if they don't have that same skill set. Because if you do get an experienced appellate advocate who knows what they're doing, and you go into it with, I'm just going to make new arguments and I'm not going to structure the brief, and I don't know even the pedestrian things like following the rules of how you craft and structure your brief can get you in trouble.
Yeah, page limits, font sizes, Connecticut's strict on those things.
Yeah, exactly. I mean, it seems, you know, picayune, but it can matter. I mean, especially in the federal courts, you know, whether it's a word limit. And I mean, that's easy enough to read in the rules, but you'd be surprised as to how many people stumble over, you know, the numerous things that have to be done. For example, you know, the Second Circuit Court of Appeals requires the docket number on the cover to be exactly 1 inch or something like that, you know, and, you know, you have to use the case caption that it's as it appears at the district court level. You can't abbreviate corporation to corp. If it's not so in the district court, it can be Byzantine, but you know, you'd be surprised how many people stumble over those rules. But even in the more substantive areas where, you know, the standard of review is huge. You know, that's something that appellate advocates know almost instinctively from having done a lot of the work on, whether it's an abuse of discretion standard, whether it's a plenary review, and not knowing the differences and not knowing at each part of your appeal, which might focus on various different areas with various different standards of review. Is it a legal issue? Is it a discretionary issue? And that can really, really change the tide of how your appeal goes if you don't understand what the appellate court is supposed to be doing. And so that's where I think that, you know, as appellate advocates, you know, we set ourselves apart from those attorneys who focus on the trench warfare that is, civil litigation.
Well, thanks, Mike. I appreciate you taking the time. I'm back to the trenches myself. Thanks for taking the time. We appreciate it,
Great.
Mike.
Thank you very much, Nico.
Have a good one.
You too.